Before we even get into the courtroom, understand this. This is not just a landlord-tenant dispute. This is a collision between foreclosure law, procedural rules, and a self-represented defendant trying to fight a system she clearly doesn't understand. On one side, a property investment company demanding possession. On the other, a family claiming they were promised a chance to buy their home back. What follows is a courtroom unraveling, where paperwork mistakes become fatal, emotions boil over, and the judge reaches a breaking point. Watch closely, because in this case, how you file matters more than what you feel is right.
In this case,
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this.
well, the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing
So,
since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been
This is where the
filed.
case starts going off the rails. The judge isn't nitpicking. She's enforcing one of the most basic rules in civil court. Captions matter because they tell the court who is suing whom and under what authority. When the defendant changed the caption and added people who were never part of the case, those filings became legally meaningless. And here's the key point. Once the judge strikes your pleadings, they do not exist unless you refile them correctly. So when the defendant insists she served everything, but nothing appears on the docket, that's a massive red flag. If it's not in the court file, legally, it never happened.
That had been filed by the defendant in this case, because she had changed the caption. They were to be refiled and served.
They were not.
Was that done?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court. We did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
Let's try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption, and serve them on opposing counsel.
Yes,
My sole question to you is,
okay.
Did you do that?
Yes, Your Honor.
Thank you. Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd. I don't see new filings in my court file.
Notice what's happening here. The defendant says the documents were filed and served. The attorney says he received nothing. And the judge who has the final word checks the court system and finds nothing. That's a credibility collapse. Judges rely on records, not explanations. This is also where self-representation becomes dangerous. Courts will let you speak for yourself, but they will not chase down missing paperwork or guess what you meant to file. So ask yourself, if you were the judge, who would you believe? the docket, or someone insisting the system is wrong.
And I don't see, and counsel's indicating he didn't get it, but she's telling me she didn't.
So according to JIS, today an answer and motion to dismiss was filed.
That was,
Not by me, Your Honor.
yes, okay, I see that, but that was not the original.
I have not seen that.
Service on here, I don't. And I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead.
Okay.
We did the same thing we did the last time.
And may I show this to you?
No,
This,
you did the same thing.
no, this notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was,
and not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am.
This is a textbook procedural error and one that instantly undermines the defendant's position. Only the plaintiff can dismiss their own case, period. Filing a notice of dismissal by plaintiff when you're not the plaintiff is like trying to fire someone else from their job, even if the defendant believed she had counterclaims. The most she could dismiss was her own counterclaim, not the lawsuit against her. The judge's refusal here isn't harsh, it's mandatory. Courts cannot allow one party to erase another party's claim just because they filled out the wrong
I
form.
am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to.
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I'm not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney.
This is one of the most emotionally charged moments in the hearing. The defendant brings up a family death, hoping for leniency or delay. And the judge does something important. She acknowledges the loss, but separates sympathy from procedure. Courts deal in rules, not circumstances. Tragedy does not suspend filing requirements, deadlines, or court orders. And from the judge's perspective, this case has already been delayed multiple times for the same reasons. At some point, compassion. It has to stop replacing
filing.
compliance.
If I may, Your Honor, briefly, just briefly. This is not a rent case, Your Honor. This is
Oh,
a
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. The backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit. She's doing everything possible to delay our occupancy, and I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in the incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And I'm just, they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started. If at all the court would go along with us, let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do
Here's
anyway.
where the case shifts from paperwork chaos to real-world consequences. The plaintiff isn't just asking for order, they're asking for possession of the home. They argue unpaid rent, property damage, ordinance violations, and deliberate delay tactics. And legally, if the lease expired and no valid defenses are properly before the court, possession becomes the central issue. The attorney's strategy is clear. Get a judgment now and let the defendant appeal later. That's not aggression. How civil litigation works when one side keeps failing to follow the rules.
Going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And what by him in this court trying to put me down because I'm representing myself is also another violation of
No,
you.
you need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay,
Yeah.
I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy, okay? This loan shark and his attorney are trying to,
Are you almost done?
yes,
Good.
to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that. If the court.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and guys want to spend all day going back and forth. Tell you what, you can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can just go back and forth and then
This is the moment every courtroom eventually reaches when procedure breaks down completely. The judge is no longer debating facts. She's managing time, fairness, and order. Courts cannot become endless arguments, fueled by improper filings. A warning. Self-representation is a right, but it is not a shield against consequences. At this point, the court is signaling that patience has run out.
I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Okay.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not going to yell when you're in here. You're not going to whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
Thank you, Judge.
Can do me a favor, can you go out there and just make sure they don't
This case is
The
a
judges-
powerful reminder that in civil court, procedure is the gateway to justice. No matter how compelling your story is, the court cannot reach the merits. Filings are proper, captions are correct, and service is documented. Here, repeated procedural failures overshadowed substantive claims about foreclosure, buyback agreements, and property damage. The likely outcomes were clear. Comply and move forward or face default consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more geo-dropping courtroom breakdowns you won't see anywhere else.